Judges will ask, why do many scientists often refuse to commit themselves and seem to hedge in their opinions? The reason that scientists will often refuse to commit themselves and seem to hedge in their opinions is because there is not an endpoint in science. The scientist is seeking the truth. Today's truth may be modified tomorrow by further studies, where the dilemma arises that in a trial, a judgment has to be made yes or no. But science doesn't work in that way. It works in small increments of knowledge, and we are always subject to having our opinions refuted tomorrow. And finally, how can I tell who is an expert whom I can reasonably believe? Judges tell me that they are besieged by experts, and they don't know whom they can trust and whom they cannot trust. I'd like, therefore, to comment and to offer some personal opinions about how I believe you can try to assess an expert witness. I would ask the following questions. What are the educational background and the training of this witness? Did the person train at a good institution and a good training program with reputable people? Second, is this person a professional witness? Does he or she make most of his living from being a witness? If the person is an itinerant witness, I would tend to have a greater level of skepticism about the testimony to be offered. Third, has the witness worked, done peer-reviewed, published research and teaching in the field or discipline in which he's testifying? Or has the person come from a totally different field and become an instant expert in epidemiology or in any other field? Does the witness always give an extreme and unequivocal position? I mentioned a few moments ago the importance of uncertainty and of changing opinions in science. Does the expert acknowledge the limitations and uncertainties and admit to the possibility of being wrong? Can the witness name other people working in the field, including some people who disagree with his position? And finally, if the witness can name those people, can the witness state the reasons why those people disagree with him?
It fascinates me that neither of you have a particularly scientific background, nor do I, nor do the majority of judges on the Federal Circuit. So we have to do a similar learning experience for purposes of claim construction to what you've done in the pretrial phase. And we depend primarily on the lawyers and on the district judge's opinion, as opposed to more technical or scientific treatises or things of that sort.
That's very interesting, because I think a lot of people assume that virtually everybody on the Federal Circuit has a PhD in some very esoteric science. So it's comforting to know that you have to struggle the same way we all do.
It can be a lawyer talking, there can be animation. Generally, the things that are most helpful for me are the pictures. I find that the pictures help educate me as lawyers draw pictures about the technology. It brings me up to speed much more quickly than trying to pour through the briefs, or at least it helps me pour through the briefs.
Oh.
So these are illustrations of expert evidence that failed to pass muster under Daubert. Daubert does raise an interesting question about the admissibility of forensic techniques that have been used for many years, but would fail the test of scientific validity, such as handwriting analysis and fingerprint identification. So that remains an open question under Daubert.
Well, it's important, Judge Schwarzer, for all of us to remember that ever since cum hotire, it's clear that these principles and problems apply to all kinds of cases, not just toxic tort or other cases involving hard sciences.
And that's become the battleground. But I think it's important to remember, as Judge Bechtel said in the orthopedic bone screw case, a case in which the plaintiffs were trying everything they could think of to keep out a particular epidemiological study. It was a cohort study, and the court said there's no such thing as a perfect epidemiological study. Most studies, even though we've had Daubert with us for a number of years now, were not conducted or designed with litigation in mind. So from a retrospective view, every study is going to have its flaws. Some studies will have many flaws, but despite those flaws, the study still may be quite useful to assist the trier of fact. So the court is not acting as an Olympic judge, grading it with 10, 9, 8, a study that may be quite flawed, even flawed to the extent that its accuracy might be impugned, is still admissible to assist the trier of fact, particularly if there are going to be other studies that form the basis of either the plaintiff's or the defendant's expert opinions.
And from your standpoint, let's assume that there has been one or more departures from generally accepted procedures in conducting this one available study. Now, Daubert talks about general acceptance, and it isn't the sole criteria of opinions anymore. But how much departure from generally accepted procedures is acceptable before a judge becomes worried about the admissibility of evidence?
Well, as you say, the essential holding of Daubert is that general acceptance is no longer a necessary prerequisite to the admissibility of scientific evidence under Rule 702, and that's a change from what the law used to be. But general acceptance still remains a relevant factor because it's likely that it will be intertwined or reflected in other indicia of validity, such as peer review, publication, testing, and information about the rate of error. There's a distinction between general acceptance of a theory on one hand and general acceptance of procedures for conducting particular study. So in the latter case, general acceptance of a procedure will probably reflect experience of the scientific community in achieving accuracy and reliability. It's of interest to look at what the court said in Kumho, that the objective of the gatekeeping requirement is that an expert employ in the courtroom the same level of intellectual rigor and that characterizes the practice of an expert in the relevant field. So a departure from generally accepted procedures may be extremely damaging and probably fatal to a finding of validity.
Ms. Cabraser, we all hear publicity or information at times about studies that have been funded by a particular party for purposes really of litigation, typically class action litigation. Does the fact that a party that proffers a study has funded it, in fact, is that a reliability issue, or do you think that's more a question for the jury to decide the weight of that evidence?
Ultimately, it's going to be a jury issue, and I think it's important that jurors know, and they will know, where studies come from, who has sponsored them, and who has funded them.
What the judge will be called upon in the course of the hearing to assess is how much error there is in the study and how much bias there has been, and whether that bias has been so substantial that it's leading to a totally incorrect outcome, thus making the study worthless. Then the court can determine whether it is exaggerating the association that the study claims to be proving, whether it's diluting that association, or maybe even masking it entirely. There are different types of bias. One of the types is conceptual bias, which means that the person who is designing the study is asking the wrong question to begin with, and that will really lead to serious error throughout the study as it's done. Part of the background of the Daubert case is important to take into consideration. One of the factors that was involved was the introduction of junk science into the courtroom. When that happens, not only may the case outcome of the individual case be wrong, but it may very well hold the entire system up to look bad in the eyes of the public. So the court was mindful of that and did intend the gatekeeping role to be taken seriously.
And I think it's well for the judge to remind herself from time to time that she's not to decide whether to believe one expert or the other, but to remain focused on methodology rather than on credibility. This fancy newfangled term of gatekeeper is really analogous to what judges traditionally do in terms of passing on whether the foundation for evidence has been laid sufficiently. only in a new and difficult and complicated context.
The purpose of the Daubert and its progeny is to facilitate a battle of the real experts. And despite the cries of junk science, which did lead to Daubert, I think it's important to remember that neither one side nor the other is the province of so-called junk science. And it's very important, particularly when there are unfamiliar methodologies or cutting-edge science or great controversy, that the purpose of the court is not to act as the scientific review board to pick the expert or the studies it most prefers, but to determine whether all of the proffered evidence is going to meet the basic assisting the trier of fact standard to be let into the courtroom.